The first matter to come before us today is State of Ohio versus Stephen Morse. The State of Ohio has waived oral argument in this case. You will have 15 minutes to present your case, present oral argument to us this morning. I'll be keeping the clock, so when we get close, I'll let you know.
Thank you.
We've read the brief, and we're ready to proceed when you are.
Thank you. If it may please the court, I'm Stephen Morse. I am the defendant appellant in this matter. And the simplest explanation to this case, in my opinion on this, is the case is journalized not once, not twice in this matter, is simply contrary to law. It's not authorized by law. It is a void sentence. Ab initio, it was void from the start. The court tried to correct it with a non-pro-tunc order from which this direct appeal is initiated. I understand, and I have, in the briefs I have filed, I understand that a non-pro-tunc does not extend the time for filing, obviously, because of the time frame in all this. I mean, this case has been before the trial court since the summer of 2013. Okay. But something as recently as State v. Williams, which initiated in this very 9th district last year, we had an opinion handed down by the Supreme Court on the same day that Magistrate Walsh issued the last request for briefings on this. And I think my strongest argument is my response to the magistrate's order of November 10th, which is simply that when a court hands down a sentence that is not authorized by law, it is a void sentence and can be challenged at any time. The court had some questions as to jurisdiction in this matter and or whether this whole appeal is moot. But the Supreme Court in Williams has stated, and in fact I watched the oral arguments and Mr. Casay was representing the state in that. And Chief Justice O'Connor says, what moves this out of the realm of just an ordinary garden variety void sentence? And it's the fact that we can challenge this at any time. We're not bound by the 30-day rule after the journalization of the sentence. We don't need leave of this court if we miss that filing deadline. And we're not barred by res judicata. It's void. It's not Mr. Casay. I watched his arguments and I've responded to his briefings here. It simply is, he would contend it's a voidable sentence. It's void. It's a nullity. The statutorily, my sentence was not authorized by law. The specification for the repeat offender, the 5 and 20 in other words, requires, Columbus has said, the legislature has said, you must impose a mandatory term of 1, 2, 3, 4, or 5 years. Whole numbers. We have no discretion. As you can see in both journal entries of the sentence, it clearly states prior specification for a definite term of 1 year. And another case out of this very 9th district several years ago, as we all know, is State v. South. That was harmonized because we had disparate opinions across appellate districts in this state, and the Supreme Court came down with, if you are giving time on the specification statutorily, you must give mandatory time. The underlying OVI time is discretionary. We have just the opposite here in this matter. initially and in the non-pro-tunc. And the transcript of both the change of plea and the sentencing here is not, it's not long. It's 10, 11 pages. You know, personally, I don't know how Judge McCarty got it wrong. I mean, it's rather simple in terms of what she was doing with the sentencing. When she, yes.
Well, I'm looking at the sentence that was handed down, and it looks like, it says for the prior conviction specification for a definite term of 1 year.
Mhm.
It doesn't say mandatory on that one, but it does is a definite term of 1 year. And then it's under the first count 1 for a definite term of 1 year, 120 days, which is mandatory for the OVI.
Mhm.
So that's where the error was, you're saying? Is on
The error is,
count one?
it is in that, correct.
That, for a definite term of 1 year, 120 days, which is
Right,
mandatory on the OVI.
If you give time, State v. Settle, Supreme Court says, if you give time on the specification, it must be, it shall be. It's that difference between shall and may.
But it does say on the prior conviction specification for a definite term of 1 year.
Definite term, but definite isn't mandatory.
So you're saying if it had said mandatory.
It has to say mandatory, a mandatory term. We have other sentences in this state. A mandatory, on a gun specification, is a mandatory term. It's not a definite term. We know that we have to, the defendant has to step that 3 years off before the imposition of the other sentence.
How much time did you actually serve? How much time did you actually serve?
A little short of 16 months. In fact, Mr. Cassay, in one of his briefs, says I shouldn't have been out because I technically had 16 months to do, because he was contending that the OVI time should have been, the 120 days should have been mandatory too. Well, again, that's counter to State v. South. We can't do that. You do not have to give time on the OVI. It is a discretionary term. And what brings us back around to another issue is that on an inspection of the change of plea and the sentencing in the transcript, it doesn't comply with the criminal rule 11. Because everything that the trial court, and Judge McCarty's a good judge, she's smart. She's one of the smart, if not the smartest one over there. I don't know how this happened. I mean,
Mr. Morse, can I ask you just to back up
Yes.
with your initial comments? And obviously in reading all this, I realized that there was the back and forth in regard to the mootness issue. And you seem very well versed in case law, and you've been working hard, I can tell.
yes, I have.
So I compliment you on that.
Thank you.
What I'm wondering is, and you probably know this, with the mootness issue, then what we have to look at is any collateral consequences. What is the residual effect? What has happened as a result of this? And usually on any type of felony conviction, that's not a problem, even though you served your sentence. But in this one, you're really talking just about the mandatory time that you've already served. So what is the impact? Why should we keep looking at this, I guess is what I'm saying.
Okay.
If that's fair.
That's a good question. It's a fair question. Thank you. I had problems with the case from the start. I want to return to the trial court to defend the charge. Yeah, the collateral damages, and I'm not certainly proud of this. This is not something I want to be here doing. 20 years from now, when I'm in my mid-80s, and I celebrate somebody's 75th wedding anniversary, and I have a glass of champagne and I get stopped for a taillight out someplace in the Villages in Florida. Yet, what's going to happen? I could be charged with a felony again. Once you have a felony DUI on your record in the state of Ohio, any other OVI is a felony. There's no 20-year look back, nothing falls away, this is it.
But
So
that's only if you can basically reopen the whole thing. If you,
right. I'm
If
going,
you can get rid of the charge.
right,
I mean, get rid
go
of
back
the
and
condition.
defend the charge.
Right, but
You know.
but if we're only talking about the mandatory versus non-mandatory time,
Right.
that doesn't reopen everything.
No, it doesn't, but I mean, we've had a long history in this state between Bezak and Beasley and Foster. I know. And that was the response in Williams, Judge Lansinger. We've had this, but it's a void sentence. We need, and again, shepherdizing this, we can go back a long ways. It's just to return the party as if there was no sentence. Return it to have the case, the sentence is void, so it must be vacated. What is the next step? It is to be remanded to the trial court as if there was no sentence for further proceedings.
But you already served the sentence. You already served the sentence.
Technically, I got 2 years. I mean, I went through the reentry court. I could have been returned to Mansfield to finish that 2-year sentence if the court had so sanctioned me and wanted to do that. In fact, for karma, the same time I'm getting timestamped for oral arguments here, I am graduating from reentry court almost to the minute, and it was almost to the minute of the day that I filed this appeal. So it's all synced up. But yes, I'm out of reentry court. I am under no longer. I could be standing here and still be in reentry court, where the court, Judge McCarty, could say, "You're being sanctioned." I was sanctioned. I was sanctioned for 3 days for not paying her fast enough for costs and fines. You know, and I mean, that was included when I came to this court asking for a stay of the costs and fines over there. I included a reentry court hearing that she said, if I had known, the transcript is available here, if I had known you were going to appeal this, I would have never let you out on judicial release. It's like, wow. You know, but in the transcript itself, I mean, this doesn't, going back to you in the criminal rule 11, she didn't get anything right here. First she told me that I would be eligible for judicial release after 6 months. That's incorrect. You can't be eligible for judicial release before you finish the mandatory time. And if the statute says you have a mandatory year, she told me then in the transcript, I will consider you for my reentry court after you do 6 months. That's wrong. What else did she tell me? She didn't, at any time in the transcripts did she tell me that the specification charge is a mandatory term. She got it right, 1, 2, 3, 4, 5 years. What she did tell me was that the underlying OVI is mandatory.
And are you talking about what we're finding in the transcript at the change of plea hearing, or are you talking about at the sentencing hearing?
The change of plea and the sentencing hearing were the same day at the same time.
Okay,
Yes.
thank you.
Okay. As I said, it's 11 pages. And in fact, at one point in it, she says, let's see, page 8, she talking to me directly before she has accepted and taken, I've entered a plea of guilty. She says, you have to have cheat sheets to make sure we get the law right here. And 120 days of the OVI is mandatory. She's looking at a laminated sheet. And having been a teacher and a professor, if you're going to get a cheat sheet, make sure you get it from the kid that's a straight A student. You know, that's why I said she's reading off of this and checking it. And we had a wonderful relationship. I hold no animosity toward Judge McCarty at all. But when she went through everything here, it just isn't statutorily correct. And then you take my plea and tell me it's knowingly, intelligently, and voluntarily made, and that it substantially complies with Criminal Rule 11, and you haven't told me anything correct. You haven't told me that the mandatory time, you haven't told me that the specification must be served first. You've gotten everything backwards.
And you have about 30 seconds left of your 15
Yeah,
minutes.
thank you. Well, I mean, I would like to, I thank the court for this time. I appreciate your acknowledgement that I worked hard on this, but it simply is a void sentence, and a void sentence has to be vacated. It's not authorized by law. Remanded to the trial court where I will proceed. And the other line of thought on this simply is, I have tried to do this from the get-go. I tried to get, I tried for judicial release after being struck by the court after 6 months, and that's when I get turned down after having it filed for 3 or 4 months, saying, oh no, you have a mandatory term. I was denied judicial after being told file for the judicial after 6 months. And then that's when I'm, mandatory time, I don't have any mandatory time, nothing here. So,
Thank you.
thank you, I
Thanks so much
appreciate
for-
your time and I await your decision.
We appreciate you coming
Thank
in.
you.
We'll take the matter under advisement, we'll issue a written decision, which will be mailed to you, as well as posted on the Ohio Supreme Court website, which can be accessed through our 9th District Court of Appeals website. Thank
Okay,
you.
thank you, Your Honor.
Your turn.